Thank you. My name is George Roberts. I've been an attorney since 1978. I moved to Nevada County in 1980 and started emphasizing bankruptcy in my practice. Probably half of my practice is devoted just to bankruptcies. And the only kind of bankruptcies that I do anymore are Chapter 7s, and that's what we're going to be talking about today. When most people say, I filed a bankruptcy, they're talking about a Chapter 7. I'll briefly touch on Chapter 11s and Chapter 13s because in rare instances, that's your best bet. There are a lot of procedural stuff that's the same, but the goal in a 13 and a 7 is different. In the packet you were given, there's something called the bankruptcy information pamphlet. We just call it the green sheet. This is a document that's prepared by the United States trustee, and that office is the one that supervises the Chapter 7 bankruptcies and sort of runs the system and deals with bankruptcy fraud. This is just a general information sheet. Most of it is correct. There are a few things that I think are not worded real well. So if you're looking through this and when we get to questions and answers, feel free to refer to this and I'll try and tie it into what I've been saying. I prepared an outline, and this is just sort of a checklist of items that we're going to go through during the day and kind of in this order. I'm fine with anybody asking questions in any particular subject, but try not to jump ahead to something we haven't covered yet, and we'll probably be able to cover more information. We're going to start off with the three types of bankruptcies. There are actually 5 or 6. There's a Chapter 7, and again, that's what most people mean when they say they filed a bankruptcy. The goal in the Chapter 7, from the debtor's perspective, is to protect as many of the assets that you have and to discharge as many obligations as you can fit into the system. Chapter 11 is a reorganization. Most people call it a business reorganization, and that's what you read when you read in the paper that an airline has filed for bankruptcy protection. So Chapter 11. It's impractical even for small businesses to use that anymore. The last one I did, the filing fee was $800, and my fee to start on was $20,000, and that usually gets you through the first 3 or 4 months. So it really is not practical even for small businesses. Chapter 13 is often referred to as a consumer reorganization. In a Chapter 13, you propose some kind of reorganization plan that involves any number of options in partially paying your creditors before you get a discharge. Chapter 13 is something that you would want to consider in cases where you are perhaps 6 or 7 months behind on your mortgage payment because of some extended unemployment. Then you get a job and you just need time to catch up. Chapter 13 will allow you to catch up your mortgage payments and not allow the bank to foreclose while you're doing that. Chapter 13 also is available if you're trying to deal with non-dischargeable obligations. So if your primary problem would be like a large IRS obligation or student loans, things like that, Chapter 13 will allow you to propose sort of a reasonable payment plan that IRS would have to accept. So those are some of the situations in which you'd want to consider a Chapter 13. The other one is if you have more assets than you can protect, but you're really in a financial jam. Sometimes you want to file a Chapter 13, partially pay your creditors, and there's a formula. You've got to pay at least as much as the unprotected value of your property. But again, in probably 95% of the consultations I do, Chapter 13 doesn't make any sense. So we're down to, and then there's Chapter 9, which is what Orange County filed. It's for municipalities, and there's Chapter 12 for small farmers. So there's some screwy little things that I'm not going to address today. This is what I've been studying since last October. These are the changes in the bankruptcy law. Probably a lot of you were aware that there was a massive rewriting of the bankruptcy law. The newspapers portrayed it as a pretty draconian change that was going to really deny people access to the bankruptcy courts. In reality, it really isn't true. There's more hoops to go through, there's more analysis, but for the majority of people up here in Nevada County, right at the beginning, the end result is more predictable. So what I'm going to do is I'm going to be talking about how Chapter 7 works in conjunction with all of these changes. And the first thing on the outline is an income analysis. The major thing that the Bankruptcy Code did is it created what they call a means testing. And essentially what that says is if you earn X number of dollars, the system can challenge your bankruptcy and call it a bad faith filing. There's a several step process, but the first thing you look at is your total gross income from all sources during the year, and you compare it to the median income of your state. In California, for a single person living alone, the median income is about $42,000. For a family of 6, it's about $85,000. So if you're below that level and you decide to file a Chapter 7, it cannot be challenged as a bad faith filing. So up here in Nevada County where the wages are lower, it actually is easier to get through the system without the U.S. trustee or creditor suggesting that it was filed in bad faith. If your gross income is above that level, then you go through a rather complicated expense analysis. We've got computers that help us, but you've got to incorporate Census Bureau information about housing costs in your area, IRS tables for transportation. It's a very convoluted process, but again, for most people in this county, if your gross income is below whatever it is for your family size, you don't have to go through all of that. And in the bankruptcies I've done since last October, I haven't had anybody that had an income above the mean income or the median income of California. So that's the income and that's the expense analysis. Next thing is assets. When you file a bankruptcy, a Chapter 7, you list all of your assets you have. Your assets include your real property, your vehicles, your furniture, investments. If you own a business, it typically involves your business equipment. And you value all of your assets. In a bankruptcy situation, you're allowed to value your assets at what's called liquidation value. So for instance, if you've got a couch, you can put a value on that on what you would get at a garage sale. If you have a vehicle, you're allowed to value that at the low Blue Book value. So you list all of your assets and you put down the fair market value. Well, actually, it's not fair market value, it's liquidation value. Then there are a series of exemption laws in your particular state, and the Bankruptcy Code allows you to use various exemptions to protect as many of the assets as you can. And I'm just going to tick off the major exemption statutes that apply. In California, if you own a home, you're allowed to protect the amount of equity you have in your house, and the amount you can protect depends on your status. If you're a single person, the Bankruptcy Code will allow you to protect $50,000 of your equity in your home. If you're married or head of household with minor children, you can protect $75,000 worth of your equity. And there's a last category where you can protect $125,000 of the equity in your house if you're at least 65. Either spouse is at least 65, or if you're 55 and have a limited income of $15,000 or less, or if you're physically or mentally disabled and unable to be employed. Any of those categories allow you to protect up to $125,000 of equity in your house. When you're figuring the equity, you take the fair market value, subtract the cost of sale, subtract all the mortgages. That's what your equity is. It's been more difficult in the last couple of years with people who own property simply because land values have gone up so fast. If you don't own a house, it's not of much consequence. In addition to the homestead exemption, there's a vehicle exemption that allows you to protect about $2,300 of value in the vehicle. And again, it's how much equity you have in the vehicle. So you take the low Blue Book, you subtract any car loans, you subtract any significant damage, and that's the dollar amount that you need to try to protect. So that's $2,300. Household goods, as long as your furniture is typical middle-class furnishings, you can protect virtually anything. So if you have a 35-inch color television and a stereo and a nice couch and a dining room table and a lawnmower, any middle-class stuff is protected, and there's no specific dollar limit. You run into problems if you have a $10,000 grand piano. Other than that, just garage sale values. There are other exemptions that protect public and private retirement systems. So if you work for the state and you're a member of the PERS retirement system, you can protect that. If you've got IRAs, you can protect them. If you've got a SEP, self-employed pension plan, you can protect that. The dollar amount that on those kinds of investments, there really is no specific dollar limit. What the exemption code says is you can protect those kinds of assets, those retirement assets, in an amount reasonably necessary to take care of you in your retirement. And I filed many bankruptcies where that kind of an account exceeds $100,000, and there's simply no way that anybody can suggest that that's plenty to take care of you in your retirement. So as part of the analysis of a Chapter 7, you look at your income, and if you're below the income, you're okay. Then you list your assets and how much you can protect. And most people who are considering bankruptcy are able to protect all of their assets that they have. In that case, it would be considered a no-asset bankruptcy. And what that means is the bankruptcy trustee will review the information that's been prepared, make sure that you're using the right exemption laws, and report to the court that it's a no-asset case. In Chapter 7s, my guess is that probably 95% of Chapter 7s that are filed are no-asset cases. And again, that means no unprotected assets. The next thing you take a look at is the type of creditors you have. And I have three general categories of creditors. Priority creditors primarily are taxing agencies. Secured creditors are creditors who have a legally enforceable document of some kind that allows them to look to a particular asset for securing their loan. The most obvious examples would be a note secured by a deed of trust on your house. The mortgage holder would be listed on your bankruptcy. They would be listed as a secured creditor, and the bankruptcy does not affect their security agreement. Another fairly common one is a vehicle loan in which the lender is listed as a lien holder with DMV. That lender would be listed on the bankruptcy as a secured creditor. They would get notice of the bankruptcy, but with most people, what they want to do is they say, I want to keep the car, you just keep making the payments. So even though that creditor is listed, you're able to keep those payments if you choose. A lot of times the car is upside down. It's worth $12,000 and you owe $19,000 on it. In those kinds of situations, the creditor is technically undersecured. In that case, if you're filing in bankruptcy, you have a choice of just walking away from that. And the bank would be allowed to take the vehicle and liquidate it, and whatever they come up short would be discharged. So there's some cases where a secured creditor really does go away, but you've got to give up your security. Another fairly common secured creditor would be department stores that arrange for their own financing. So if you go to Best Buy and buy a big screen TV, they have what's called a purchase money security agreement. That means that they can look to that one item. If you file bankruptcy and you don't want to pay Best Buy, they can take that back. It's at their cost. They have to come pick it up. So let me give you an example. You go down to Radio Shack, and Radio Shack says, well, we can arrange financing on this $2,000 computer. A year later, you decide to file bankruptcy. You still owe $1,800 on the computer. The reality is the computer probably is worthless by that time because it's outdated. So Radio Shack, if they want to, they can come pick up an outdated computer, but frequently they just won't bother because they're going to take a computer, wipe it off, and try and sell it to a public that recognizes that it's out of date. So sometimes you have secured creditors that go away anyways. Then you have unsecured creditors, and that is where the bulk of the benefit comes from in Chapter 7. Unsecured creditors include most credit cards, Visas, MasterCards, Discover, Macy's, Penny's, any of those kinds of credit cards are generally unsecured. Now, Penny's or something like that, you can if you buy a washing machine and use a Penny's card instead of a Visa card, they've got one of those purchase money security agreements. But overall, unsecured creditors are the ones that cause people to consider bankruptcy. So, and again, it includes most credit cards, virtually any medical bills, personal loans, credit lines. I frequently see people who have been operating some business in town, and they owe vendors, suppliers. Those are all generally unsecured debt. When you get your discharge, it's the unsecured debt that goes away. And when I say go away, what happens at the end of your bankruptcy is you get a federal court discharge order, and the order says your legal obligation on these kinds of debts ends, and then there's a permanent federal court injunction that says none of these creditors can ever do anything in an attempt to collect. So that's kind of how you get from being in debt to not having to worry about it anymore when the process is over. The next item is the discharge and exceptions to discharge. Exceptions to discharge fall into two categories. First is if you commit any kind of fraud in the bankruptcy proceeding itself, your entire discharge can be denied. An example would be if you didn't tell them about a significant asset, they discovered it, that's fraud. You didn't list it hoping that nobody would find out and that you wouldn't have to give it up. In those cases, not only are your debts not discharged, but you can never include them on a future bankruptcy and get them discharged. So the idea of committing fraud in a bankruptcy because you've got a $3,000 car you don't want to lose is not only illegal, it doesn't make a whole lot of practical sense. Yeah.
About unsecured creditors. How do you dissolve your relationship with them? Or how does
Well, give me an example. A credit card?
Yeah.
Credit card, they get notice of the bankruptcy, and if they... Well, let me give you an example. And this happens about every 4 or 5 months. We get a discharge, and the client comes back 2 months later and said, I'm getting a bill from Bank of America, and they're demanding payment, and they say I'm overdue. I'll take a copy of the discharge, and I'll send it to Bank of America and say, well, you already got notice of this. I'm giving you another copy, and the next time you send a bill, you're going to be sued in federal court. And about every 3 months, I do it. And as soon as it gets to Bank of America's legal department, they call me and say, we're really sorry, it slipped through the cracks, we'll pay your attorney's fees, and we'll never send a bill again. So that's how you get the accomplishment of getting them off of your back, is there's a federal court order that's really rigidly enforced against creditors. Bankruptcy judges don't buy the idea that it was a computer error or, we made a mistake. And, they've got 4 months to stop the billing, and if they keep doing it, they pay the price. Any other particular situation?
No.
Okay. Another thing while we're talking about...
What do they need to leave me alone? What do they need to see?
Well, when the bankruptcy is prepared and we file it, we provide a computerized mailing matrix to the bankruptcy court, and within about 5 days of our filing it, the bankruptcy court itself sends out a notice to every creditor. And the notice says, this person filed a bankruptcy, it was filed in this court, it's the petition date, here's some significant dates, and at the initial filing of the bankruptcy, there is a temporary federal court injunction that protects you during the 4 months it takes to get through. So the minute you file, nobody can sue you. If they've already served a lawsuit, you don't have to answer it. If somebody has already won a lawsuit, they can't do anything to enforce it during the bankruptcy. They can't garnish your wages. They can't put a lien on your property. So the protection you get from the bankruptcy court starts the minute it's filed. The creditors get notice about 5 or 6 days later. at the beginning, you'll still get credit card bills for a month or two, but the discharge is 4 months later, and if they haven't stopped billing by then they're in trouble. Discharge and exceptions to discharge, they have made some changes in what kinds of debts are subject to a discharge. We've already talked about losing your entire discharge if you commit fraud in the bankruptcy proceeding itself. In addition to that, there is part of the bankruptcy code that has a checklist of items that are absolutely non-dischargeable or maybe non-dischargeable. The absolutely non-dischargeable debts include, it used to include government-guaranteed student loans. Under the new bankruptcy law, it includes all student loans. So if you went to a private tech school and they lent you the money, they have the benefit of claiming that it's non-dischargeable. There is an exception to student loans. It's called a hardship discharge, but it's really, really, really hard to get it. Basically, what it amounts to is if the court believes that anywhere in your future life you're going to benefit from the education and earn enough money to pay it even though you're on the street, you're not going to get it. So you need, in a broad sense, consider all student loans to be non-dischargeable.
I read of a case recently where somebody who had gone to law school and didn't pass the bar, that he wasn't able to discharge those loans in bankruptcy.
Yep.
Is that
It isn't just your ability to use that kind of an education. It's if you have the ability at any point to make any kind of payment on that at a bare substance, whatever that word is, substance level, they're not going to let you get a discharge. It really, really is one of those rare times where the law really means what it says, and that is extreme hardship. All family support obligations are automatically non-dischargeable. Child support, spousal support. In those situations, as is in the student loan and with the taxing agencies, those creditors don't have to do anything in the bankruptcy. They're listed on the bankruptcy because they are creditors. But those that are automatically non-dischargeable don't have to get involved in your bankruptcy, and when it's over, you still owe the money. There is another category of creditors that may or may not be discharged. And there is part of the bankruptcy code that says if you owe money as a result of fraud, or if you borrow money in contemplation of bankruptcy, then the creditor has the right to pursue you in bankruptcy court and sue you in bankruptcy court over that issue. So that's one where it's not automatically non-dischargeable, but it can end up that way. Now, let me give you some of the more common examples. Somebody took a $3,000 cash advance, and 6 weeks later they're filing bankruptcy. When the bank gets notice, they pull up your account and they see that you took out $3,000 6 weeks before the bankruptcy. That looks like you were kind of setting them up. You took it, you knew you were headed to bankruptcy, you knew you couldn't pay them, and you were just going to file bankruptcy in a few weeks. In those kinds of situations, the bank can sue you and try and convince a judge that you intended not to repay that when you borrowed the money. And that's exactly what the judge has to find, is that you intended not to repay it, or that no reasonable person could ever believe that they'd repay it. But it's not automatic. I had a client a few years ago who borrowed $5,000. He had lost a high-paying sales job, and so he borrowed $5,000, and he bought some kind of it wasn't the wisest thing to do, but he bought some franchise where he went around to trade shows and county fairs selling, what did he call it? Birthday reminder kits. For $40, he'd sell this kit to you, you'd sign up on the internet, and they'd remind you anytime a family member had a birthday or something. That went to trial, and we had him bring in the money he paid for the franchise, all the flyers, all the fees that he paid to set up booths all around county fairs and trade shows and stuff, and his total sales were about $200. Well, the judge said, was not a really great business to invest in, but the judge believed that when he borrowed it, he had a reasonable belief that he would be able to benefit from that and start paying his bills. And he fell flat on his face, but that $5,000 was discharged. What triggers that kind of a response from the bank are two things. It's how much you borrowed and how close to the bankruptcy. So if you borrowed $5,000 12 months ago, that's not going to trigger anything. If you took a $300 cash advance 2 weeks before the bankruptcy, that's not going to trigger anything. It's too small to even deal with. The other thing that affects the bank's decision is if they feel that you've borrowed money in contemplation of bankruptcy, when they file the lawsuit, they're arguing only about that dollar amount. So if you have an $8,000 balance on your credit card and it's been running for a year and you're not making any headway, and then you take $3,000 and then file bankruptcy, it's that $3,000 that's issued, not your whole $11,000 balance. So banks do give some thought before pursuing it, and usually what happens is they'll get a notice, and the first thing they'll do is they'll write a letter to me and say, please explain any circumstances we're not aware of. And it does happen. Example would be, I'd say, well, right after they took this cash advance, she was hospitalized and she lost her job, and here's the documents to support it. That change of circumstances between when you borrowed the money and you file bankruptcy is enough to convince the court or the bank that they'll never win. So a lot of times it's relatively easy to head off that kind of a situation. Trying to think of some of the other things that are potentially non-dischargeable.
What about a judgment?
Judgment doesn't really directly affect the dischargeability of something. So let me give you an example. You haven't paid your credit card. They refer it to RCA. RCA files a small claims court lawsuit, and they get a judgment against you for $5,000. If you then file your bankruptcy, the $5,000 is discharged, the attorney's fees, the filing fee, the interest, everything is discharged. So taking a debt and having it converted into a judgment does not make that creditor any better off. Now, there are some situations in which it gets more complicated. Let's say you've gone through that process, you've got a $5,000 credit card, they get a judgment against you. If you own property, they can put a lien on your house. And that makes it more difficult. So the $5,000 is discharged, but to get the lien off your house, it's a separate procedure, and we can frequently do that. We can even have a lien removed, a judgment lien removed, depending on the amount of equity you have and some things like that. But just because somebody has sued you and successfully sued you doesn't mean that that debt becomes non-dischargeable. Yeah?
Do they consider the abstract of judgment as secured?
Well, all right, here's the way it works. They get a judgment, and then they fill out an abstract of judgment, and that's filed with the recorder. What that procedure does is it creates a lien on any property that you own. So if you don't own a house, if you're a renter, filing an abstract of judgment really doesn't do anything. If you do own a home, and they've recorded this abstract of judgment, and they have what's called a judgment lien on your home, that can be removed, and it can be removed if the amount of your equity is within that homestead exemption. So even if you own a home, even if you've lost a lawsuit, even if they put a judgment lien on your house, it's fairly common to be able to have that removed. What happens if you wait that long is Uncle George's fee here is about $1,000 more. So, I mean, there's a whole process you can get through, but if there's enough at stake, yeah, we can do it. Yeah.
What was the homestead ceiling?
Well, it depends on your status. It's $50,000 if you're single. It's $75,000 if you're head of household or married. So you can be a single parent with minor children. And it goes up to $125,000 if your either spouse is 65 or 55 with a limited income or physically disabled. Now in California, the law says that top category, the exemption law says $150,000. But as part of the bankruptcy code revision, they put a cap of $125,000. The bankruptcy code says regardless of what your state says, we're capping it at $125,000. The main reason for that was because Texas and Florida had unlimited homestead exemptions. Everybody knows that O.J. Simpson went down to Florida, bought a $5 million mansion, and then filed bankruptcy. In Florida, a $5 million house, free and clear, was protected from judgment creditors. It was happened to be George Bush's and Jeb Bush's two states. I'm sure that was just a coincidence. But part of the bankruptcy change was whatever your state says, it's capped at $125,000. So it depends on your status. Yeah.
Okay, you said the fraud cause of action isn't or may not be dischargeable. What about torts arising from criminal conduct? Say,
well, there's two different things. One other category of debt that is non-dischargeable automatically are court fines, typically restitution because that's part of your court order. But if the way you phrased it, you said a tort associated with criminal conduct?
Well, the fraud thing is kind of self-explanatory, but I was thinking a DUI,
there's a couple other exceptions. Generally speaking, if you are underinsured and you cause an accident, that is a dischargeable obligation. If you are driving under the influence and you're convicted of that, you can't get rid of that debt. There is another exception to a discharge, and that is if you have caused deliberate injury to a person or deliberate damage to somebody's property. That is, you assault and battery, anything like that. If you're sued because somebody deliberately caused you injury, but that's one of those things where the creditor has to take the initiative. It's sort of like the bank alleging that there was some kind of fraud. If you've injured somebody and it was deliberate, it's the creditor's obligation to go into bankruptcy court and convince a judge that it should be accepted from discharge. There was one of our local attorneys who did a trial down in Fresno, and he got a $3 million verdict against a bar and a couple of drunk people who went outside and kicked somebody to death. And one of those kids filed bankruptcy. And that's where I got involved because we know Scott Fielder. He did a great job on the trial, but when it came to bankruptcy, he said, "George, what do we do?" So we had to actually go into bankruptcy court, and it wasn't real difficult because he was convicted and we waive a piece of paper. But in a lot of cases, it's the creditor's obligation to intervene in the bankruptcy court and say, wait, this fits into that exception. So intentional torts, meaning a deliberate injury to somebody or a deliberate damage to somebody's property, would be one of those where the creditor has the opportunity to ask that be non-dischargeable.
Well, I understand you're drunk and you do the assault and battery, but you're drunk and you don't mean to.
No, a DUI has its own separate little paragraph.
Right, but I'm
so intentional torts and DUI is either or.
Okay, I'm talking about the effects of being drunk and causing an automobile accident, injuring somebody, being sued to the court, but having it not, I mean, it kind of is in a gray area. It's not an intentional assault or a battery.
But here's the way the bankruptcy code dealt with that. They've got a checklist. They say the following are not dischargeable, are exceptions to the discharge. One of those paragraphs is deliberate injury to somebody. The next paragraph down, either or, the next paragraph says any injury caused by a DUI accident. Okay. So the argument used to be, well, I was drunk and I shouldn't have been driving, but I didn't intend to hit this car, so it's not an intentional injury. And 20 years ago, that was a legitimate argument because the bankruptcy code said you had to intend the injury. And you get into some legal nuances. Some attorneys used to think that if you did an intentional act that hurt somebody, that would be good enough. Example was this guy was cutting down a tree and he had a little 18-year-old kid helping him. The kid wasn't paying attention. the tree fell and killed him. And so the guy that cut down the tree was sued, and he filed bankruptcy, and the attorney said, well, that was a deliberate act. He intended to cut down the tree. Well, the bankruptcy code says you had to intend to cause the injury. So and that's why people, lawyers drive them crazy as they start drawing lines like that. Yeah?
Say you have 4 or 5 unsecured debts, this credit card, and you really want to keep paying them once you can use it. Do you have to discharge that?
You have to list everybody you owe money to.
Sure, you list them all.
You have to list them all. Then, and it is very common today, and has been more and more common over the last 6 or 7 years, for one or more banks to write to me and say, we understand times are tough, and we're sorry your client had to file bankruptcy, but they've been a good client, and if they sign this document, we'll let them keep their credit card. It's called a Reaffirmation Agreement, and a Reaffirmation Agreement creates a new legal binding obligation. So if you have a credit card with a small balance of $700 or $800, and the bank says, look, sign this and we'll let you keep your credit card, and we'll even raise your balance a little bit.
And you keep paying on it, right?
Then you keep paying on it. But you're recommitting yourself legally.
Right.
And the danger in that is you get out of bankruptcy and 6 months later you're realizing that you really can't keep up with that debt. So in order to avoid those kinds of problems, if you have an attorney, I have to review the reaffirmation agreement. I have to discuss it in detail with you, and I have to declare under penalty of perjury and file with the court a statement saying that I believe that this is in your financial best interest and that it's not going to hurt you economically. If you don't have an attorney and you want to sign a reaffirmation agreement, if you're doing the bankruptcy, through a document preparer or something, then you have to go in front of a judge, and the judge is going to do the same thing. The judge is going to say, look at your monthly budget. You hardly even have enough gas money. Why do you want to sign this? So it is possible to sign a reaffirmation agreement, and now we're starting to get banks who are writing to me and saying, well, they owe $3,000. If they reaffirm on $1,500, we'll let them keep the credit card. They're even doing sort of like a discount sale. And the truth is that banks realize that even people who have filed bankruptcy are still a good source of squeezing them for 18 and 20% loans. And they've gotten over the I've been wounded kind of attitude, and this is just something that I've seen is anecdotal, but it's very common for me to see people on the street and they'll say, oh, my bankruptcy was a year and a half ago and I got 3 credit cards, I'm doing fine, I've got a new car loan. So the fact that you filed bankruptcy, the consequence of that just isn't as what it was 15 or 20 years ago. I've got a thing over here. But the bottom line is creditors will say, okay, you filed bankruptcy, let's take a look. What kind of a loan you're getting, what's your job history, what's your income. The extreme example is I did a bankruptcy for a medical doctor who was a heart specialist, and not in this county. And his income was $40,000 a month. And he was $4 million in debt because he thought he'd be a businessman and build a medical center, and he fell on his face. Well, the day after his bankruptcy was over, he was able to go down to the Lexus dealer and get a car loan because he had $40,000 of income. It was not a problem. Yeah. For what?
For going any further with anything past the regular bankruptcy.
Well, let's see.
Like say you file for somebody and then a couple months later you get something in regards to them.
The way I practice law is I always follow up and I don't charge anything. So if somebody's giving you a problem on a discharge debt, I follow up. And if it's with a bank, what I do, let's say you filed bankruptcy and you got a discharge 3 months ago or a year ago and some creditor is still trying to collect on it. What I'll do is I'll say, I'll sue the creditor, I'll send you the bill for the time I spend on it, but if I don't get it from the bank, you don't owe me. I always do. We say there's one over here.
Yeah, if you're in arrears on payments on a secured loan, does the payment stop and then Can they still repossess a vehicle, that type of?
Well, when you file the bankruptcy, let's say you're 3 or 4 months behind on your car and they're threatening to repossess it. When you file the bankruptcy, you have this automatic injunction that prevents creditors from doing anything, including repossessing your car, even though they have a security agreement. And so the creditor has two choices. One is they can wait till the bankruptcy's over and then repossess the car because this automatic stay isn't in existence anymore. Or they can get an attorney, file a motion, and go into court and ask to have this injunction modified. And their argument would be, if we're required to wait another 4 months, we're going to be even farther in debt and we'll never get our money back. And so the court would typically say, okay, you can go ahead and repossess the car. Now, if you're 3 or 4 months behind on the day you file the bankruptcy, if you can get the money together to bring that current during the bankruptcy, then you keep the car. It's not a problem. The other thing to keep in mind is when you file the bankruptcy, your situation is judged as it exists. Well, there's one exception. Generally, it's what your situation is on the day it's filed. So if you file on June 1st, your salary for June, July, August, and September while you're in bankruptcy, that's yours. You can do anything you want with it. The exception to this is, and if anybody has questions afterwards, I'll go through some more detail. But one of the other really, really screwy things that they did with the bankruptcy code when they changed it is we talked about your current monthly income. Well, your current monthly income under the new bankruptcy code is not your current monthly income. Your current monthly income is the average monthly income of the preceding 6 months. And what that meant was I had a client who had been out of work and he was up to his eyeballs in debt, and he got a new job paying something like $8,000 a month, which put him, in theory, way over that median income level. But according to the bankruptcy code, his current monthly income on this job he just started, you add up the prior 6 months while he was unemployed, divide it by 6, so his current monthly income while he's earning $8,000 a month, according to the bankruptcy code, was $600 a month. So it's not everything is exactly what it is on the day you file. The reverse situation of that is if you've been earning $10,000 a month and you lose your job and the industry collapses and you're never going to be able to earn that kind of money again, and the next day you want to file bankruptcy and you're unemployed, according to that same formula, you add up the prior 6 months and your income is $10,000 a month, and you're saying, well, what happened? I don't have it anymore. In those kinds of situations, what you do is you just wait 6 months to reflect that lower income. On this fellow who got the brand new job, we had the opposite problem. We had to get it filed really quick so that his unemployment situation was counted.
One more question. If you have an IRS lien seizure, does the bankruptcy also stop that?
It will stop IRS from virtually any collection activities during the bankruptcy. There's another thing in here. Let's talk about that here. In this pamphlet here it says, for example, you cannot discharge debts for, and then the first category says most taxes. Well, the truth is that you can have personal income taxes discharged, and I do it on a fairly regular basis, and sometimes it's hundreds of thousands of dollars. There's just a checklist you go through. Is it personal income tax? Is it due and owing for at least 3 years before the bankruptcy? And did you file a non-fraudulent return at least 2 years before the bankruptcy? A situation would be you were self-employed. The end of 5 years ago, you had a good year. You filed your return, and you say, "Well, I owe $20,000, but I don't have it." If it's 3 or 4 years later and you file bankruptcy, that is a dischargeable obligation. And I bet more attorneys a glass of beer that I can get rid of taxes. So, yeah, but it'll temporarily stop the IRS during the bankruptcy. Once it's over, then they can go back and try and enforce it. Yeah.
Can I I do a quick clarification?
Sure.
I know we're running low on time, but following up on what Yolanda was saying, I just want to clarify civil tort versus criminal cases. I'm understanding you to say that in a civil action, if there's an intentional tort, an intentional battery or something like that,
right,
that's not discharged. If it's just something like negligence, perhaps,
absolutely,
yes.
yeah.
In a criminal case, let's take the example of a reckless driver. No alcohol, no drugs. Driving recklessly injures somebody because of reckless or negligent behavior.
Yeah.
Certainly
Dischargeable.
did not intend to hurt anybody.
That's dischargeable. Not
criminally prosecuted, convicted, ordered restitution in the amount of $5,000. Criminal court ordered restitution.
Well, what happens is that really is not, it probably doesn't fit in the category of civil damages. It fits into court fines and restitution.
Right.
So any money that's owed as a result of the criminal activity or the criminal conviction typically is not dischargeable.
Okay.
Although even in those cases, I had a fellow that filed a bankruptcy, and he was ordered to pay restitution during his probation, and 5 years later his probation was over, and he still owed $30,000 or $40,000, and we were able to get that discharged into bankruptcy because of some screwy little, subparagraph something somewhere. So
older stuff maybe, newer stuff probably not.
Well, generally speaking, if it's a criminal fine or restitution, it's not dischargeable.
Okay, if my goal was to become a serial bankruptcy filer, how long would I have to wait between filing?
All right, first of all, under the old bankruptcy law, if you received a discharge in a bankruptcy, you couldn't receive another discharge for 6 years. It doesn't mean you couldn't file a bankruptcy. It means you can't get another discharge for 6 years. Under the new bankruptcy code, they've changed that to 8 years. Another important part of that is when you file any kind of a bankruptcy, you get this automatic stay, an injunction that says creditors can't do anything. The most common kind of serial filing would be a Chapter 13. You've got a renter, and he's going to be evicted. So he files a Chapter 13. The landlord has to fumble around to get an attorney, go in there. The tenant dismisses his Chapter 13, and the next day files a new Chapter 13. Starts the whole process over. They've handled that situation, which usually was frequently a nightmare for landlords. Under the new bankruptcy law, this automatic stay, this injunction, it does pretty much the same thing on the first filing, but the next time you file a bankruptcy, that automatic stay goes away after 30 days. The third bankruptcy, it doesn't even exist. So there's two different aspects of serial filing, but as far as discharge goes, once every 8 years. Okay?
I have a question
Yeah.
about past-owed taxes. Once you have an injunction filed, you're safe from being harassed by the IRS, but once it's over, they can...
If the taxes are not dischargeable. It's just a temporary relief. That's all it is, yeah. And I'm going to go through this last stuff pretty quick. These are the process itself. First thing, and I'm going to do this really quick. The first thing under the new bankruptcy code is you are required to take a credit counseling course before you file your bankruptcy. It has to be through an approved agency. The United States trustee has to say it's okay. And you have to pay a fee, you have to get a certificate, and that has to be included when you file your bankruptcy. The next thing they've required is there's a stack of notices that's about 20 pages, and we've got to provide that to the client. They have to sign that they received it. I've got to sign something to the court saying I gave it to them. So that's the documentation. We have to provide a copy of a tax return that we never had to do before. So there's lots more paperwork. Then once the bankruptcy is filed, there's another course you have to take during the bankruptcy, and that's called a financial management course. And you have to complete that before you get your discharge. When I was going through this book and realizing how complicated it was getting for people, the way my office does bankruptcies is when you come in, and if you decide to do it, my fee is a flat fee. We set up that initial course. We sit you down at the computer in our library, or you can log on and we get you a pass number. take about a 30-minute internet course, get the certificate. You don't have to pass a test. You don't have to answer any questions. And they send the bill to my office, and that comes out of my fee. Same thing during the bankruptcy when you have to take a financial management course. It's a group telephone conference, specific time of the day. You get on the phone and you listen for an hour and a half. Don't have to answer any questions. Don't have to pass any tests. But during the course, several times during the course, they give you a code word you have to write down. And at the end of the course, you have to give them the code word, and the only point of that is to make sure you were listening. You didn't set down the receiver and go watch television for a while. So neither one of these courses require you to learn anything. Neither one of them require you to pass any kind of a test. And somehow Congress thought that this was going to solve what they thought was an abuse. Yeah?
Do you have the fees on these two courses you have to take, the one before?
The internet course is, the one you take before is either $50 or $75, either per person or per couple. My secretary knows, I don't know. And then the financial management course, same thing, it's $50 or $75. But on these, we've found companies that are approved, and we've set up accounts, and so you take the course and they put it on my credit card, and then I pay that out of my fee at the end.
So what is the typical fee now?
About twice what it was before. On what I call a typical no problem Chapter 7, my fee is $1,900, and then the bankruptcy fee that's paid to the court is $299. $20 of that goes to Homeland Security, and I have no idea why bankruptcies are involved with that. And then out of that $1,900, I pay for all the courses and do everything. But the biggest problem with the change in the law, it's a bureaucratic maze. There's lots more paperwork, and ultimately the end result is pretty much the same as it was before this great bankruptcy change. Going through here real quick here, we've talked about required courses, documentation, we provide all the notices, and we've got a checklist, so we remind you all the way through, this is what you have to do next, and if you don't do it, my secretary calls, and then if you don't do it, she'll call you again, and then she'll call you again, so we babysit you through the whole thing. The petition is much more convoluted. Some of these income and expense analysis, we've actually got built-in software that does the analysis as soon as, after we've inputted the information. Then there's a meeting of creditors. About 5 weeks after your bankruptcy is filed, you have to go to Sacramento. My fee includes going down there and meeting my clients and going through these hearings. The meeting of creditors is conducted by a trustee. The trustee's function is to review your petition, make sure that he understands all the information, and go after any assets that are not legally protected. As I said, 95% of bankruptcies are no-asset bankruptcies. Even under the new law, where there's a lot more documentation, most trustees schedule 10 to 12 hearings every hour, day after day, hour after hour, and they expect to finish those 10 within the hour because they've got another 10 cases. So typical hearing takes about 5 minutes. Questions they ask you are, did you review everything before you signed it? Did your attorney explain what you're getting into? Are there any changes? Are you sure you've listed all of your assets? Are you expecting an inheritance? That's another odd little thing. Bankruptcy code says if you become entitled to inherit an inheritance, meaning somebody dies and you're named in their will, if that occurs within 6 months of when your bankruptcy is filed, they get it. So it is important when you have I've got a client right now whose mother's 98 years old and in a nursing home in frail health, and I say, well, if she dies within the next 6 months, whatever your inheritance is going to go to the bankruptcy court. Well, she didn't own anything, but that's something you have to be aware of. The special issues, we've already talked about those, the student loans and support obligations. There is a new law, and the attorneys in particular should be aware of this. There is a new part of the bankruptcy code that says if you file a bankruptcy and you owe support obligations, that those support obligations trump your exemptions. So if you've got a client that is owed child support or spousal support, and the party that owes the money files a bankruptcy, you can go into bankruptcy court and you can go after assets that would otherwise be protected, and it's pretty significant in the family law practice to keep that in mind. Okay, now there's problem. I've tried to explain all of this in the last hour, and I'm quite willing to take any questions anybody has.
On a typical bankruptcy, how many hearings can I expect to go to?
One, and that is the meeting of creditors. And in a typical bankruptcy, you'll never see a judge either. It's just a trustee, very informal.
Thank you, George.
You're welcome. Any other questions? Yeah.
So the $5,000 cash advance on the credit card.
Uh-huh.
If you bankrupt in a month, they're going to look at you.
Yeah.
If you do it in 12 months, no one's going to say anything.
Typically.
Is there some rule in the middle there?
There
90
is.
days is good.
There is just my practical experience. I've prepared probably 1,500 bankruptcies in my career, and generally speaking, the closer to the bankruptcy and the larger the amount, the more chance there is for getting a reaction. There have been situations where I've been shocked that a bank didn't pursue something, and there have been cases where it's like $2,000. Why are you wasting your time? Keep this in mind, though. If you had a cash advance situation, and it's one of those gray areas where I don't know they're going to go after you or not, I'll give you my best take on it. What I tell the client is, why don't you make your decision on whether or not to file a bankruptcy, assuming that you're going to be stuck with that. And if it still makes sense, go ahead, and whatever way it falls, it falls. But again, what happens in those cases is typically the bank will write to me first. And if we head it off, that's fine. That's part of my flat fee. And what gets into more fees is if they actually file the lawsuit and I'm supposed to handle a trial for you. But even if they say, well, we're going to pursue it, then they send it to a bankruptcy creditor attorney. I had a situation where a girl borrowed $3,000 and she filed bankruptcy, and she said, well, I realize I may have to pay this back, but I've got to do it. And so it went to an attorney, and the first thing the attorney did was call me, and we got the summons and complaint served. First thing he did is say, we'll take 50 cents on the dollar to settle this. So it's $3,000 that were so close to the bankruptcy they would obviously survive, and first thing they say is, give us $1,500 and we'll go away. Now, $1,500 is a lot of money, but if you've got mom or dad or a brother or somebody, you can take care of that problem. Those kinds of the negotiations, informal stuff I do as part of my fee.
Have you ever gotten involved in any compromises with the IRS as far as compromising debt?
I don't do what's called an offer and compromise. Typically, it's accountants and CPAs that do it. They're either dischargeable or they're not.
What if they're in the process, though, if you've gotten involved in
Well, you can work out an offer and compromise, and if it's dischargeable debt, you can still file bankruptcy and change your mind. I mean, that's like any situation. If you're having problems with a creditor, and you say, all right, I'm going to sign this, agreement to pay you $5,000. There's nothing more than just a written agreement. That doesn't change anything. You can still turn around and file bankruptcy. Did you have a question over here?
I do.
Yeah.
How long is the credit going to be affected by the bankruptcy?
Well, that goes back to the medical doctor that earned $40,000 a month. He didn't have any problem getting credit of any kind under any circumstance. Generally speaking, once you filed bankruptcy, the credit industry generally will say, okay, we see your bankruptcy here, now let's take a look at your income, your job history, what kind of credit you're getting. If your income is enough, you can go down the Roseville Auto Mall and any car dealer will get you a new car loan if you've got those things. It's sufficient income and some job history. The day your bankruptcy is over, so you get your 4 months, you get your discharge, and then go down there, and if you've got enough money, if you want to get back in the rat race, they'll get you a loan. Now, what they'll do is they'll use secondary lenders that want a little more down and higher interest rate, but you can do it. There's another thing that I've observed, and that is about every 4 or 5 months, I'll get a call from a former bankruptcy client who will say, I'm buying a house or I'm refinancing a house, and the lender wants a copy of my bankruptcy to make sure that all these debts are gone away and that I'll be able to make my mortgage payment. So mortgages, car loans, all those are available depending on your particular circumstance.
State Board of Equalization.
Yeah, it's nasty, nasty people over there.
So, you owe...
State Board of Equalization, you're talking about the sales tax. That is not money that you owe them. That's their money that you stole. That's their view of it. So it's not a debt. You have their money. And they will come after you, and they don't care. And they won't budge an inch. And there's no way to get that discharged. Going back to the taxes, if you owe payroll taxes to employees, those aren't dischargeable. It's only personal income taxes.
So the State Board will lay off during the 4-month period.
That's correct, but they won't let you keep operating.
Right.
And then there's a whole different world of stuff to consider. If you own your own business, it is usually fairly easy to keep that business open and operating during the bankruptcy. But it's a real delicate line you have to do, because if you don't do it right, the trustee will come out there and he'll say, give me the keys to your door, and he'll put a bankruptcy sign on your front door and take over. So in order to avoid that happening, there's a lot of preparation work and contact with the trustee. But if you run a business that has limited assets that you can protect, there is a way to keep your doors open and keep it running.
What was it you said, or would you say the sentence again, about most Chapter 7 cases are non-asset cases?
Right. Most people who file bankruptcy are allowed to protect everything they own.
But most people who own property that's worth more than $125,000?
Of equity. Yeah?
Equity, not value.
Okay.
Yeah.
Okay.
Yeah. But that has been a problem because of, it's a problem that all of a sudden you're worth $300,000 or $400,000 more. Yeah. Well, part of that effect is, if you're in that circumstance, you're going to have to consider refinancing and pay your debt off. But, the day in, day out, I would say the clients that I see, probably 1 out of 4 own their own home. And again, the increase in value is sort of a two-edged sword. Any other questions? Yeah.
Landlord tenant. You said that if the tenant files bankruptcy, it would stay the landlord from evicting him?
Well, actually, that's one of the new changes in the law, is if the landlord already has a writ of possession. That means he's already gone into small claims court and got an unlawful attainder. If he's got a writ of possession, he can enforce that. But if you're behind on your rent, he can't start the lawsuit without doing something, going into bankruptcy court and getting permission.
Okay, what if it's an unlawful detainer based upon just a 30-day notice, not lack of rent? Is it still stay if it's not?
I believe it does. But before you give that advice, I'll give me a call and I'll do some research on it. I don't know everything off the top of my head.
Yeah.
Does a bankruptcy void a tenant's lease in a business situation?
Generally speaking, when you file a bankruptcy, you can walk away from any lease or contract. The concept is this. If you have a lease for business, like a business premises, when you file a bankruptcy, you can just say, I'm breaching my lease. That means I'm not complying with it, and that means I owe you, the next 8 months of rent, but that's a discharge obligation. So any kind of a contract or a lease is something that you can choose to terminate.
What about a delicate situation where you have a business, you have customers, they've given you deposits. Now, you may go out, you've got customers now that are creditors, basically.
Yeah.
Did you list each of them individually? Did the court look askance at that?
I've had that situation before, and it may be the end result may be from exactly what kind of quote deposit you're talking about. There may be, if you're an artist, you may put your artwork in on a consignment. Well, if that's a situation and your art piece is sold and the gallery owes you 50% of that, that really is more sort of like the State Board of Equalization. It's your money. But if you give a deposit, I'm trying to think. Now, if you were renting a house and you'd put a $1,000 cleaning deposit down and you filed bankruptcy and you wanted to stay in that house, that $1,000 is still an asset of yours. So you have to do something with it.
This money, I'm going to get you a bicycle. So I got a $50 deposit from you, and I'm going to get a bicycle.
Did
but
you?
I don't get you the bicycle.
What was your intention when you did the $50?
Well, obviously to try and stay in business and do the business.
Well,
it's a gray area.
Yeah, it's a gray area. I would say probably if you filed the bankruptcy, it would be the one that gave you the deposit would be their problem to deal with it. And that rang a bell. What was it? You said something about? I don't know. It's Friday. I usually don't work on Fridays. Any other questions? If you have your outline, there's my name and address. If anybody is interested in more information, I don't charge for a consultation. I'll sit down with you and go through the particulars of your situation and tell you if you want to think about it. That's fine. Don't charge for it.
Just want to give us your phone number for the video.
Oh, okay. My office number is 265-3279. My address is 301 Broad Street above Utopian Stone. I've been in the same chair in the same window for 25 years and I haven't been bored yet. So thanks for your attention and give me a call if you have any other questions.
Thanks a lot.
You're welcome.